Hi, Megan. How are you?
I'm good, Maya. Thanks for having me.
Well, I'm very happy and excited to see you because although we're friends and I've known you for many years, I actually never had the opportunity to interview. So it's really very nice to finally be interviewing you today. And we're going to be talking about something that I know it's almost like one of your niche areas. You practice in criminal law in general, but you also have a particular focus on mental health issues. And you're located in Ottawa. And so you know a lot about the practice of mental health in the criminal context in Ottawa and in the East region. So I'm very excited to talk to you today about that because we're going to be talking about NCR, the NCR verdict, what it means. Is it a good thing? Is it a bad thing? And if it's unavoidable, what can we do once we're stuck with that verdict? So let's start, Megan. And if you want to add anything just before we start, I gave a brief, very brief introduction, but if you can add more just for people to know more about you and how they can find you.
Sure. So I work at my firm. It's called Davies McMahon LLP. We're a team of five lawyers, and we always have a student. Our practice is any and all criminal files, but we do have a large proportion of clients who have mental health issues. We are often representing clients who are dealing with fitness proceedings before the courts, clients who want to be found NCR, or clients where they've been told the Crown wants me to be NCR and I don't want to be NCR. So we're often in contested NCR proceedings. And then we also represent clients once they are either found unfit to stand trial in court or have been found not criminally responsible in court, and their matter is traversed to the Ontario Review Board.
All right, very nice. So as I mentioned, we're going to be talking about NCR. So let's start with the basics. I know a lot of people know what it is, but some people may not totally know what NCR means. So let's start with that. What is NCR, Megan?
It's often categorized as a defense, but that's almost like a misnomer. For certain offenses, it's always going to make more sense to go NCR. Obviously, the big ones being murdered, or if you are facing the prospect of the Crown bringing a dangerous offender application, or maybe even a long-term offender application on conviction, then maybe exploring whether your NCR is the right move. But for lower level stuff, like for accused who are looking at less than 2 years in custody, unless they're doing really, really well in the community, which is significantly different than how they were at the time of the allegations, it might not make sense to be NCR because it's an indeterminate sentence. Like there's no, once someone's found NCR, their matter leaves the criminal court system. And they go before their provincial or territorial review board, so the Ontario Review Board in Ontario. And there's no minimum time under the board, there's no maximum time under the board. So, I mean, I'd say the quickest we see people get out from under the board is getting an absolute discharge, which means you're done with the board at their second hearing. And their hearings only happen once a year. There are circumstances that warrant having a hearing more often, but for as long if there's no significant issues in
The
the course,
rule is
the rule
every
is once a
year,
year.
once a year.
And
And
you'll often see clients with like minor stuff, like who are found NCR on relatively minor things, like an assault
yeah.
or a few mischiefs, and they can end up under the board for like 10, 15 years.
Right. So also just to clarify, NCR is not criminally responsible. So that's why it's taken out of the criminal justice system, because at that point the courts find that the person doesn't have the criminal responsibility and therefore they need to be dealt with the Ontario Review Board in Ontario, which is a board, a tribunal of experts, psychiatrists, and lawyers, a member of the public who will make decisions moving forward. Now, the NCR then so like you said, it's sometimes considered. I mean, we like to think of it as a defense, but it's not really a defense, but it's really more taking the person outside of the criminal justice system. But is it a good thing or not?
Yeah, so it's a verdict.
Hmm.
And in some cases, an accused might decide that it's a verdict that they want and it would be more
Hmm.
favorable to them
Yeah.
because you don't have a criminal record when you're found NCR.
Yeah.
So that's It's a huge win. You're not going into jail, which is a huge win.
Hmm.
But the downside is you're followed by a forensic team, like a team of at least one psychiatrist, probably a psychologist, an occupational therapist, a social worker, lots of nurses. You might be detained in hospital. So you're living in a forensic hospital.
Yeah.
We have different levels of security in different forensic hospitals. They have like some of them have double locked wards. Some people end up in seclusion for years. So it really depends on the person's security classification. But to get into that system, you have to first have a mental disorder, which
Yeah.
is a term defined in Section 2 of the Criminal Code. And then Section 16 of the code tells us that the accused either has to, because of their mental disorder, have like lack the ability to know what they're doing, which means you're
At
so
the
mentally
time of the
at the time
offense.
of the
Yeah,
offense,
that's
you're
very important.
so unwell, you don't even know that you're like
Yeah.
stabbing the person you're stabbing.
Yeah.
Or you are so unwell that you did not know that what you were doing was wrong, which is
Yeah.
usually where most people end up. So for some people, they might do an evaluation of their circumstances and what's important to them, like not going into custody, not having a criminal record, and they might decide, I want to go NCR. But for other people, like people who I mean, I think the people who tend to do the worst in terms of the clients that I've seen, people who have concurrent disorder. So where
Hmm.
there's a major mental illness and there's substance use,
Yeah.
that's a really tricky combination because the board always wants people to be substance free.
Hmm.
Their substance use has to be tied to the risk that the accused poses to the public. But it can take years to demonstrate that the
Right.
substance use is not part of the risk that the person poses. So if you're not willing to stop using marijuana or alcohol or whatever else it is that you like doing, that can be a real barrier. So it's not so much that it's a good thing or a bad thing in general for the system. It makes a lot of sense. It's a really good verdict to have. It's an incredibly important verdict to have. It's just whether any specific accused should be pursuing it. It's a really personal decision. And before they make that decision, they need to be well informed by their lawyer about what all the pros and cons are so that they make a fully formed decision before pursuing it.
Okay. Now, but in a case where the person really has a very serious mental health issue, it's isn't it unavoidable to have them get into the NCR and under the jurisdiction of the ORB?
I would say it depends on what the offense is. If you
Hmm.
have someone charged with murder and they have a prior diagnosis of schizophrenia and they weren't on their meds at the time, you're probably still going to be required to get two assessments to get a Crown to even consider consenting to an NCR verdict on something that serious. By contrast, if you had the same person in the same like mental state doing something much less serious, like assaulting a random person on the
Yeah.
street, the Crown might be really gung-ho about having this person found NCR. So sometimes the facts of a case will kind of like ring out or call out and attract the Crown's attention. They say, I want this person to be found NCR. Like, this is the route we should be taking if there is a finding of guilt. But oftentimes it's in the accused's hands. It's like if you want to raise it, you can raise it. But I have found practicing in Ottawa and just my office usually representing some of the most unwell people who come before the criminal
Yeah.
justice system in Ottawa. I've certainly had many cases where the Crown has said if this person is found guilty, we'll be seeking an NCR verdict. And so it's helping the client fight that if they don't want to be found NCR.
Okay. But again, in terms of fairness, though, Megan, I mean, if a person has a serious mental health problem and has been suffering and struggling with this mental health problem for many years, isn't it more fair for them to be under the jurisdiction of the Ontario Review Board? Wouldn't the board be in a better position to deal with their situation as opposed to a criminal court? Because it's either they're going to be in criminal courts or under the Ontario Review Board. Now, obviously, the best scenario with them for them would be not to deal with either or, but once they're in that situation, they're kind of stuck. They're either going to be in one case or the other. But from a person who has a serious mental health perspective, wouldn't it be better for them to be under the ORB jurisdiction as opposed to a criminal court?
It might be better from like a human perspective, but at the
Mhm.
end of the day, it's their call to make if they want to try and raise the evidence, try and prove on a balance of probabilities that they were NCR at the time. If they don't want to pursue it and the Crown's not pursuing it, it's their choice to make. When it comes to fitness, I mean, I agree with you completely. We can't move a matter forward when an accused is unfit. They can't make decisions about whether they want to plead guilty or not guilty. They can't make decisions about what in the allegations they agree with or disagree with. So you're
Mhm.
really stuck. You can't do anything. We have to move that person in front of the Ontario Review Board if they're found unfit and they're not likely to respond to treatment, or a treatment order after 60 days has not rendered them fit. We're stuck. We can't do anything. But for someone who was super, super unwell at the time that they committed the offense, and they likely come within a Section 16 verdict, my practice is it's up to them. If they want to bring it, let's bring it. If they don't, let's fight it, or let's just keep quiet and hope no one else brings it up. I let them, make the autonomous decision.
So let's deal then with the worst case scenario for the client where they don't want to be found NCR, but they are. So now they're stuck. Are they stuck? What avenues do they have?
Yeah, so once you're found NCR, you're stuck with it
Hmm.
on until one of two things happen. You either get an absolute discharge from the Ontario Review Board. So to get that, the board has to find that you do not pose a significant risk to the safety of the public. Like I said, that could happen at your first review board hearing, which is required to be held um, very shortly after you're found NCR. I will say those hearings almost never happen in the prescribed time of 30 days. We're often seeing like 4 to 6 months
Hmm.
for these hearings. Um, but if we don't want to go that way, or it's taking too long, or the person kind of disagrees from the outset, you can
Yeah.
appeal your NCR verdict.
Mhm.
And sometimes it's a situation where there was a contested hearing, and you're really just, kind of challenging the judge's decision, and alleging that there was a legal error. Other times, especially if it's something like a consent NCR and it's years later that the accused decides, I want to challenge this. Sometimes we'll get a transcript, because my office does a lot of NCR appeals, where you'll see that no procedural fairness was followed.
Hmm.
Like,
So can you explain more about that? Like, what do you
sure. So
mean?
the first thing is, like, even if everyone wants to be found NCR, like the Crown wants the accused to be found NCR, the accused is advancing an NCR
Hmm.
defense. Usually what happens is there's a report from a forensic psychologist,
Yeah.
or a forensic psychiatrist. There's one report that's filed. Everyone relies on that report because it says the accused NCR. And oftentimes the psychiatrist isn't called to give oral evidence. They're not cross-examined. Everyone's on the same page. But sometimes in these hearings, because everyone just wants to get it done quickly and everyone's on the same page, procedural fairness just goes out the window. So I've seen transcripts where the accused is not arraigned, they're not put to their election, they don't enter a plea, there's no facts read out, or like all these things are required to happen. Like, first of all of the things that would be required for a criminal trial or a criminal plea of guilt have to happen, even if it's a consent NCR. So the accused has to be arraigned. If they have an election, they have to be put to their election. If it's a summary, or sorry, if it's a hybrid offense, the Crown has to elect. The allegations have to be read out. The accused has to enter a plea, and the only two valid pleas are guilty or not guilty. Section 606 of the code doesn't have an I'm not NCR. That's not a thing.
Yeah.
You're either guilty or not guilty. So what happens is the accused should plead not guilty. There will be facts read in. The accused can agree that, I'm not challenging those facts. Essentially, like a plea of like nolo contendere. Like, you're not challenging the Crown's evidence. You're not seeking to cross-examine any witnesses. You're not calling any witnesses, but you can't admit that you did it, but you're not challenging the Crown's case. And then often there is a finding of guilt that is made or registered by the judge. And then we get into the NCR evidence, which might just be like everyone is agreeing that Dr. So-and-so's opinion establishes that the accused was suffering from a Section 2 mental disorder and meets the first or the second branch of the Section 16 test, and they are NCR. But all of those steps still have to happen, and the judge's reasons still have to, like, the judge's reasons have to state that the accused suffered from a Section 2 mental disorder, and has to explain how the evidence relates to them being NCR on like the first or the second branch of the Section 16 test. So all of these things still have to be followed. And when they're not, it's a really, really great way to appeal an NCR verdict. And I'd say
And
that the best kind of appeal grounds are usually on consent NCRs. There's usually something that went wrong.
okay, they don't follow the appropriate procedure that should be followed. Where does that appeal go to, the NCR appeal?
It depends on, so if the The Crown proceeded by way of summary conviction.
Mhm.
It's an appeal to the Superior Court. If the
Okay.
Crown proceeded by indictment, it goes to the Court of Appeal, and both are appeals as of
So
right.
it's
Like
just like a regular, any other criminal appeal.
exactly.
Okay.
Another thing we can do on appeal is even if, like, especially if we're trying to undo an NCR verdict. Another thing that I've had a few lately is where after the passage of time, an accused psychiatrist starts to think that this was never like a mental health issue and this was substance-induced psychosis,
Hmm.
but it's something that's only borne out after many years. And it's like, well, we haven't had this person treated with medication in 5 years, and we haven't seen any evidence of psychosis. And we know he was using like a lot of marijuana at the time. So we're starting to think it was substance-induced. So if you can get an opinion from a forensic psychiatrist saying that this was substance-induced, you can file an appeal. You can bring a motion to extend the amount of time to file your notice of appeal because you have 30 days, right? Just like any criminal
Yeah.
appeal. So you can file a motion to extend that time, explaining that you got this fresh evidence and it will very likely be granted. And then you can file an application or a motion to introduce fresh evidence on appeal. And your fresh evidence can be your psychiatrist's opinion saying that at the time this person was an NCR, they weren't suffering from a Section 2 mental disorder, or even if they were, that's not the
The
like
main
main thing.
reason. Yeah.
Right. Um, so yeah, that's another way to undo an NCR.
Now, for the NCR, what's critical here, I guess, Megan, is the report. Um, I mean, that's the basis of everything, right? It's like you need that medical report where there's a doctor's opinion that this person should be found NCR, or it's their opinion that the person didn't know or understand the nature of their acts at the time of the offense. But then what do you do if, let's say, like, is there any way to, other than cross-examining, I guess, the doctor, to challenge that opinion if you, as a defense lawyer, you disagree with that opinion? Because I find, and I may be wrong, but courts tend to agree most of the times with the medical report on the NCR assessment. So, but what if you want to challenge that? So, obviously, there's cross-examination. We can talk maybe a little bit about that as well, what you think is important to do when we want to cross-examine a doctor on that. And then uh, what else can happen?
Yeah, so if you've had a trial and the client is found, there's a finding of guilt after trial, then there's going to be probably a lot more to work with factually compared to if it's like a plea.
Hmm.
There's just going to be like a bigger record. So, I mean, it's still down to whatever the trial judge's decision was, but it's just making sure that the psychiatrist didn't go outside the bounds of what facts were actually accepted. So, whether it's like an agreed statement of facts or whether it's a judge's reasons for decision or reasons for judgment at the end of a trial, you want to make sure that the psychiatrist has based the finding that they're NCR on actual findings that were made by the court in terms of facts. One thing that can be helpful in is trying to show that there were things that the client did that showed that they knew that what they were doing was wrong, because that's usually the branch of NCR that someone's found NCR on. It's not super common to have someone who's so unwell that they don't know what they're doing at all. It's usually they don't know what they're doing is wrong. So to try and highlight that the accused did understand what they were doing was wrong. So like they fled from the police when the police there was like a chase that pursued because the person started running away from the police.
Yeah.
That might be an indicator that they knew that what they'd done was wrong. So like little things like that to try and highlight that the test isn't met. It's going to be so fact specific. It's hard to give like this is what you should do every time. But another piece is going to be the medical records. If there are medical records, if this person has a history, like if they were hospitalized around the time of the allegations, you're entitled to get their medical chart. You can get your client to sign a consent and an authorization and direction. You send that to the hospital. You explain what medical records you want. The hospital will release all those to you. Might be 50 pages, might be 5,000 pages.
Yeah.
You can go through that and figure out like if there's other information that might be helpful about how your client was behaving, or if there was any evidence suggesting that there was substance use,
Well,
whether it's
Well,
after.
actually, sorry to interrupt, but because
No.
I do have here a question that I want to know, because what happens sometimes, especially when we're dealing with a client who already has a mental health problem, because again, from a criminal perspective, it's not just the mere fact of having a mental health. It's like it has to affect you while you're committing the crime.
Yeah.
So sometimes we have clients who have a mental health problem and they have been followed by a psychiatrist for many years. What if I want to call that psychiatrist? Because he would be in a much better position to evaluate the client and to make a determination or to make an assessment as to NCR than a psychiatrist who's going to be called by the courts and who's just getting to know the client just from reading about the client and having one or two interviews with them, or I don't know how many, but it's definitely not the same knowledge that the client's own psychiatrist has. So, what can we do here if that's what we want?
Totally. So, the clients, depending on like what their prior situation was, the client psychiatrist is probably not a forensic psychiatrist.
Hmm.
So they wouldn't be able to give the same opinion, but you can still call them to give evidence. You can still speak to them in advance to get information. You can still collect their notes. You can, you're entitled to call evidence in like defending that the person is not NCR. But another thing you can do is whether there's this prior mental health history or not, is you can retain your own psychiatrist privately to do an NCR assessment, like a second opinion, but hoping that the person's not NCR. Anytime I've had a Crown or a court after trial order an NCR assessment where my client doesn't want to be NCR, um, I will, even if it's legal aid, you can seek funding from legal aid for a privileged assessment. I've never had legal aid deny one. You just have to kind of explain why it's important to get one of
Yeah.
these. And you can pick whoever you want. So this is where I will go to the psychiatrist that the Crowns always pick. Like I want someone who never finds anyone NCR. Like I'm hoping that I'm going to get a report that says my guy is not NCR
Hmm.
because then I can call this psychiatrist at the hearing. I mean, I'll usually give the report to the Crown in advance in the hopes that it's like, look, are we really going to spend 2 to 3 days with this battle of the experts to try and figure out if Mr. So and so is NCR on this theft, or can we just like let it go? But if it's a court-ordered assessment, especially after trial, you're probably not going to convince a judge you're not going to convince a Crown to just let it go. You might actually have to have the battle of the experts. But it's worth pursuing. It might give you a second thing. If you then end up with a report that's not favorable to you, it's a report that says the person is NCR. You just keep it to yourself.
Yeah.
No one has to know about it, and it is what it is. Another thing that can be helpful about that is sometimes the psychiatrists, when they're doing the assessment, because they will have, if the court's assessment was done first or the Crown assessment was done first, you'll have a copy of that. You can give it to the psychiatrist
Yeah.
that's doing the assessment. You can ask if they see any like obvious issues or whatever, that might be something to explore. Another thing, though, is if there's anyone else involved in writing the report. So I have had cases where a forensic psychologist was involved and they did an assessment of the client and they came to a different conclusion than the forensic psychiatrist about what the
Mhm.
diagnosis was. And so that gives lots of, kind of lots of fodder for cross-examination, but it also allows you to call that psychologist as a witness to even call into question what the diagnosis is and if that would meet the Section 2 criteria or if it assists in showing that your client is not NCR.
But in that particular case, for example, wouldn't the courts give more weight to the opinion of a psychiatrist as opposed to a psychologist, or not necessarily?
Not necessarily. Sometimes it's going to depend on, how the psychiatrist testifies, if they can explain why their assessment differed. Like in my case, the psychologist had spent like 30 plus hours with the client and the psychiatrist had spent two. So it was
Hmm.
really, the psychologist's evidence was really powerful because she like knew this person.
Yeah.
And, so in a situation like that, it's like, really, you met him for like 1 hour on this day and 1 hour on this day, and that was your conclusion. So
Yeah.
it's going to be fact specific.
And hence, if the client already has a medical professional following them for many years, I would submit that they're in the best position to make that assessment or determination. Uh,
Especially if the like previously treating mental health professional has a different opinion on
yeah,
diagnosis than your forensic
yeah.
psychiatrist doing your quarter assessment. Huge, 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 huge.
And one of the things that I wanted to ask you, Megan, is that we've recently seen a few cases where some of these doctors, psychiatrists, their credibility has come into question in some decisions where it seems like they weren't properly doing their jobs, or they were just too busy that they weren't
Copy and
giving.
pasting notes from other
Yeah,
people's reports. Yeah.
exactly. So, I mean, it is a little bit of a tricky and dangerous area, right? Like, how can you trust the psychiatrist, especially if you don't know them? And well, in that case, it wasn't actually a case of not knowing them. It was someone who the courts relied on for and crowns relied on for so many years, and then it just turned out that they weren't doing their jobs properly. But this is really very concerning because these whole cases turn on these uh, reports. So, what do we do when we're, feeling a little bit weird about a report?
Yeah, so sometimes you'll get information from your client that will make you really question something
Mhm.
that the psychiatrist has written, and that's when I find it's helpful to see if there's any other medical health professionals that have dealt with the client to try and figure out, was this all in the client's head? Is there something to this? Like, is there something I can use? But you're also entitled to ask for like their notes, like they're any other expert, right? Like if we had an expert in a different area, like a collision recreation expert in a dangerous driving case, you'd be asking for like the notes that they made in doing their assessment and writing their report, if there were previous drafts of the report. So you can ask for these kinds of things. It's not something we do often, but we certainly can. Um, you can also, oh, I just lost my train of thought. Oh, it'll come back to me, Maya.
No worries.
Oh, I know what I was gonna say. I always, even when you think you've dealt with a psychiatrist lots of times, like I know this person, I always look up reported cases.
Hmm.
Um, Usually the psychiatrists are treated like usually the judicial like comments about
Yeah.
an expert are pretty good, but sometimes you will find something that has been said about a psychiatrist or any expert, but psychiatrist because of what we're talking about, that they've been like careless in their notes or were like really summary in their evaluations or summary in their meetings or interviews or just some carelessness, something that maybe was not like to like the best standard, and as a result, the court couldn't rely on their opinion in that case. I'm always checking anytime I have a contested NCR in case there's a new decision I've missed about a psychiatrist, especially if they're not one that I deal with all the time, in case there's something in there that I'm can just, whether it's inspiration to check in my report, like, oh, like maybe they didn't spend that much time with the client, or maybe this is something else I should look at. But also to, if it's something that you're seeing a pattern of, and there are some experts or psychiatrists where you will see this and you will find multiple reported decisions that are not favorable, you want to be, making that submission at the end that this psychiatrist has been found in other cases. It's not necessary, it may not be relevant at all if the issue is not the same, but it's something to at least explore and figure out if it could be relevant in your case.
And in average, how much time should the psychiatrist spend with the accused? Like, what would be an amount of time that you'd be like, okay, this is good enough for them to make a valid assessment?
Oh, I mean, I think part of it is going to depend on what they're charged with and like the
Hmm.
volume of the
Okay.
disclosure.
Yeah.
Um, Although if it's a court-ordered one, they're just going to be going on the summary of the facts. They probably don't have a ton of information. Um, but like I think you're going to want like a few hours. I don't
Mhm.
know that I've ever seen anything less than like 4 to 5. And I've definitely seen like 7-ish, but it's also not like a ton of time.
Yeah, 4 to 5 is not a lot.
No, no. I think if I saw something that was an hour or less, that would be
Hmm.
concerning.
Yeah.
If I saw something around the 2 hour mark, I think I'd probably kind of have some questions. But if it was 3 hours plus, I'd say that's pretty consistent with what I see in reports.
Okay. So then once we have this evaluation and we have, let's say, determination, and we were talking about this. So once we have the NCR verdict and the client is stuck with it, so there are appeal avenues. So
Yeah.
the person can appeal just like any regular criminal appeal.
Yeah.
And then usually, what are the grounds of appeal that are advanced for these types of appeals?
Um, so yeah, so it'll be like the things we've already talked about, like introducing fresh evidence that they weren't
Hmm.
NCR at the time of the offense, that procedural fairness or procedural regularities were not followed for a consent NCR. Um, Past that, it could be really anything and everything. It could be that the judge misapprehended the evidence upon which they base the NCR finding on, like they relied on something that wasn't proven. It could be that the judge erred in law and they, misinterpreted the legal test for how someone is found NCR. Um, so it would be like any other criminal appeal.
Okay. All right. And then once the person is found NCR and there's no appeal or the appeal fails, they will have to go under the jurisdiction of the Ontario Review Board. So, can we just briefly talk? And I know I don't want to take much more of your time for today, and I'm hoping we will continue our discussion on mental health, especially focused on the Ottawa area, Megan. But just briefly, so especially if we want to talk about Ottawa, like what happens then? Once the person is found NCR, what happens to the accused person? Well, they're no longer now dealing with the criminal justice system, but where do they go and what happens to them in Ottawa?
So their bail status is presumed to remain the same. So if they were in custody, they presumptively stay in custody. If you're out on bail, your bail conditions continue unless there's an agreement or something else is worked out. Like if sometimes when someone's doing really well in the community, we might vary their bail conditions with the Crown's consent to do something that to allow them to do something else because things are going so well. Sometimes, although not often, you might be able to finagle a consent release. While you're waiting for the first hearing, but that's usually where someone has started medication in custody. They're now doing really well compared to
Yeah,
how they were at the time. There's like a safe place for them to live. There's supports in the community, so that's not very common. So the presumption is your bail status remains the same. If you're in custody, in Ottawa, it's very unlikely you're going to be have a bed in hospital by the time
right
of your
away.
first
Yeah.
hearing. Yeah, your first hearing will probably be within like 3 to 4 months, and you'll probably get moved to hospital, I'd say within 4 to 6 months of being found NCR. It could be longer. We had one recently that was 8 months from NCR verdict to when they actually got a bed in hospital. So that really sucks. Once you have your hearing, your bail, and you get the board's disposition, which is their decision,
Yeah.
then your bail conditions don't apply anymore, or your status in custody doesn't apply anymore at the jail. You're then in the forensic system, but you have to wait in jail until they have a bed for you in the hospital that's dealing with your file.
Yeah.
Um, Usually, if the person is living in the community at the time they're found NCR, the hospitals don't have beds. They do not want to bring someone into hospital who is doing well in the community. So if you're doing well in the community, you have like a decent place to live. Even if you have a detention order from the board, there's usually a condition that allows you to live in the community if the hospital approves of where you're living. So the hospital's one of the first things they're going to want to do is do a site visit to see where you're living, do this approved accommodation assessment, see if they can give you a big green check mark, and that way they don't have to worry about bringing you in unless something goes very, very sideways.
And in Ottawa, what hospitals will the can the person be expected to be transferred to
So
eventually?
usually it's whichever hospital does your
Assessment? The
exactly your
okay.
assessment. But no, like if the person has connections to Ottawa, we will do everything to get them to be dealt with in Ottawa. If you are at a different hospital, you can apply for a transfer. There's ways of you notify the hospital in advance, you ask for their input on whether they would take your file. The hospital that you're at gives input onto whether they support you moving there. The board has to approve it, but that can be done. But in your like average case in Ottawa, the person would go to the Royal Ottawa Mental Health Center. Unless for some reason their security classification required them to go elsewhere. Sometimes security classifications require someone to go to the Brockville Mental Health Center, which is
Mhm.
more secure. If you're someone who, because of their security classification is much higher, sometimes people go to Waypoint, which is on the other side of the province, because that's the most secure
Well,
psychiatric
which is hard if the person is from Ottawa and their roots are
daily.
in Ottawa. It's very
Yeah,
difficult.
yeah. But your average situation, it's the Royal Ottawa Mental Health Center.
Okay, but I do want to ask you here one question about the fact when there is a decision for a person to be transferred to a hospital that's not necessarily in their area where they usually or normally live. Is there a way to contest that?
So, like, do you mean for the first hearing, or do you mean like once they're in the system? Because usually, once they're in the system, sometimes, like, we've definitely had clients, especially female clients or
Mhm.
Indigenous clients, sometimes, if there's a reason the hospital wants them to go somewhere, like to North Bay, for example, because it's closer to, um, like, or there's, so sorry, there's a program they can access there
Yeah,
that
that
Ottawa
is
doesn't
more
have.
suitable for them. Yeah.
Yeah, and the client's like, I don't want to do that.
Yeah.
Whether they have family in Ottawa or not, like they just might not want to go there. So you
Yeah.
can always oppose it. Whether the board agrees with you is something else. But no, you certainly you can initiate a transfer. You can oppose the hospital's request for a transfer. So everything is possible.
And if the hospital decides that they will still have to go, is there a way to change that decision, or you're just stuck with
Yeah,
the,
so the board's the one that ultimately makes the decision. And
sorry,
then
if
if
the board decides?
Yeah. So the client can appeal it. Every Ontario Review Board disposition for that accused, you have an automatic right of appeal to the Court of Appeal for Ontario. So the accused can appeal that.
Okay. And
Yeah,
that will go
questions
to
of
the
law.
Ontario Court of Appeal.
Exactly. So questions of law, fact, mixed law, and fact, just your standard appeal stuff.
Okay. All right. So, Megan, I wanted to thank you because this was really very good. There's a lot that you told us about NCR, and I know that this is a very difficult area of the law. It's very niche, very specific, and not a lot of people know about this. You're one of the few that I know in Ottawa who practice in this area, and it's really very nice to hear from you. And hopefully, we will be recording more of these interviews where we get to talk more about mental health, especially with a focus on how it works in Ottawa, because I know it's very different from other parts of the province. So thank you.
Oh, thank you so much, Maya. I'm happy to do it.
Thank you very much. Bye.